Argument of law and rule of voir. So when the question of admissibility comes before the court, it is the judge who has to decide that whether some evidence is admissible or not. So defense during the prosecution case, during the hearing of prosecution witness could argue that this evidence is inadmissible before the law. So then judge has to decide whether the argument or the witness statements are showing up the evidence which is admissible or not. Frequently, the defense will object to a piece of prosecution evidence being given in evidence. The argument may be, for example, that it is irrelevant to an issue in case, or that its admission is into evidence would cause unfairness because the evidence was taken by breaching the codes of practice that the police may have to practice. As argument about the admissibility of evidence is the argument of law, so the judge is the tribunal of law in the crown court. So then the judge has to decide whether to accept that kind of evidence or not. As judge is the tribunal of law, he will decide the argument in the absence of jury. So judge will ask the jury to leave if this question arises. Sometimes he will have to hear evidence before he can decide a matter of law. For example, the defense may argue that evidence of a confession should not be given because the defense was not told his right to legal advice. The police may say, but he was told of that right. The judge would have to decide that issue of fact before ruling on the law. He would hear the evidence from the police and the defendant, and if defendant chooses in the hearing, the judge will decide that it is voir dire or not. And if the judge decides it's voir dire, that it is not acceptable because the evidence was taken by breaching the codes of practice, he will rule that the evidence is inadmissible in the court of law.